Francisco, California. And as a defense attorney, I spend my time representing people who are accused of crimes. I represent people accused of all sorts of crimes, but I also concentrate on representing people who are accused of computer crimes and related offenses. So I have some experience in this, but from the opposite side of the fence than Mr. Hyde did. So I'm going to talk to you about what is problems that are raised because of the international nature of crime that occurs on the internet. And then I'm going to go through in some detail the current proposals to try to resolve some of these problems. And I will address these proposals and these problems with more of a defense side bent than I think Mr. Hyde did. But I will welcome you to ask me questions during the presentation, but I'm going to try to save some time for questions after as well. So if I do raise something you want to comment on right away, just raise your hand and let me know. Okay, the internet is an international medium, and therefore crime that occurs on the internet is international crime. What the internet does is it connects offenders with victims that could be very far away. In the old days, before we had the internet, the times when crimes were truly international, that is where evidence was located in a lot of different countries, or where the offender was one place and the victim was another place, was far more rare. This makes it a lot easier. Usually, in order to sell drugs to somebody or to assault someone, I have to be pretty much in the same room with them. Now I can steal or rob something and I can be many, many countries away. That means not only do we have questions about where the victim is and who's going to be able to, in other words, what sovereign is going to be able to seek redress or justice for the victim. We also have questions about where the offender is and whether the offender is going to be tried in their home country or brought to the place where the victim is located. But it also means, in addition to those complicated questions, where are we going to find the evidence and how are we going to find the evidence? Because I may be in the United States and perhaps I attack a computer in Israel, but the evidence could be located in France and in Pakistan and other places like that. So so those are problems that are raised by its very international nature. These problems I'm going to separate into two types of issues. Procedural issues, by which I mean sort of a how-to, and substantive issues, by which I mean what. What are the crimes and that sort of thing. So the fact that investigation is international poses these procedural difficulties. If I am, and I'm going to just use my country, the United States, as an example, if I'm an investigator or a law enforcement agent in the United States and there's evidence that's located in the Philippines, then I need to rely upon people who are in the Philippines, law enforcement people in the Philippines, to do investigation for me. Why does that raise a problem? Well, first of all, I don't know whether the people in the Philippines have the kind of training that they need to collect the evidence, first in a way that I think is reliable and is going to catch me the right perpetrator, but second in a way that's going to mean that I can use it in my United States court of law. So while my training has prepared me for that, perhaps, I cannot be assured. I don't know whether the training of local investigators meets up to those same requirements that my court is going to impose on me. I don't know whether the local investigators are going to have the resources available to do the investigation. Sometimes these things are very expensive. I may need to have media to copy the evidence onto, and I've dealt with cases where there's gigabytes and gigabytes of evidence. You need to have the media to copy it onto, you need to have the resources to go through it for some part of the investigation that may be expensive. For example, doing a wiretap or a data intercept, I don't know whether the other country has the resources or the manpower available for that. I really may have no idea, and so that can be a constraint or a limitation on my local investigators, even when they may feel like they want to help me. But they may not feel like they want to help me. There may not be any kind of cooperation between me and the investigators in the other country. And that could be for a lot of reasons. Law enforcement often tends to be kind of territorial, and sometimes local investigators don't want to take orders or obey the dictates of the American FBI. It could be interpersonal. It could be that our governments are not particularly friendly. Or it could be that what I'm investigating, the crime that I'm looking at, is simply not a crime in the other country, which is what we saw with the I love you virus. It wasn't a crime in the Philippines, and so there's a limitation to the level of cooperation that a local law enforcement agent can give me when the thing I'm investigating isn't even illegal in their own country. And finally, there may be some problems with cooperation, or because the crime may be happening. It may be something that's just occurred, and I need to have quick access, either to get the suspects while the gun is still smoking, the keyboard's still hot, or I need to have the evidence I need to have them do a wire tap or a data intercept or something like that right away so that I can catch this person. And it could be night in the other country and it's the middle of the day here. It could be maybe they don't speak English, maybe there's local constraints in terms of the kind of legal authorization that the local law enforcement needs before they can give me the kind of help that I want. So I don't know when when the investigation and the focus of the investigation is so far away, I don't know whether I can have quick access either to the evidence or to the suspects or to the judicial process in that other country. What else? Record keeping and the collection and preservation of data. The other country may not have standards for that. The United States doesn't really have standards at this point in time, but they may not have the resources or the money or the ability to maintain the kind of records that I would want to have for my investigation. There's also problems with data intercept or wiretap and whether I can get that, as I said earlier, and whether I can get that in the other country and the same as quickly as I want, whether they have the resources available to do it, and whether I trust that the way that the other country does it is going to be a way that's going to be acceptable in the United States court. And somebody asked, I just want to mention this, somebody asked earlier what the standards are for doing a wiretap or a data intercept. And the standards are different from country to country. I know that in the UK the standards are somewhat less than they are in the United States these days. The United States has, for wiretap or real-time data interception purposes at this point in time, some rather rigorous standards that you have to meet in order to get a court authorization for that. And that is sort of a hallmark of one of our privacy considerations for people's telephone calls and that sort of thing. It is by many standards, by even my defense attorney standards, a high level of proof that you have to meet before the court will authorize law enforcement to listen to your phone conversations. And when I talk a little bit later about the Cybercrime Convention and some of my concerns that I have with regards to data interception and that kind of thing there, you'll see that I'm coming from a standpoint where I like the way that it is in the United States and think it should be at least that protective or more so, not only in the United States but also for citizens everywhere. Very sticky problem is the issue of trans-border searches. So if the evidence is located in another country and my investigators from the United States want to go in there and search for that evidence, you can imagine the problems of having foreign law enforcement coming into your country and going into your citizens' houses and searching around through their personal papers and taking their computers and that sort of thing. It raises a lot of international problems, both because countries are want to preserve their sovereignty and are also very concerned about the privacy of their citizens. And I can tell you that, if we tried to have law enforcement agents from the People's Republic of China coming into the United States and searching our houses and hard drives for evidence that we were members of Falun Gong or something like that, there would be certainly an outcry, and I think that other countries feel exactly the same way. Not just about the People's Republic of China, but about the United States law enforcement agents as well. The question with transporter searches also is whether or not you're going to provide notice, and not just notice to the foreign government, but whether the suspect is going to be able to get any notice in advance of these kinds of searches or seizures of their data as well. And finally, the questions of jurisdiction and extradition. By jurisdiction, I mean where will the suspect be tried, or by who has the right to try the suspect. And by extradition, I mean whether the country that has the right to try the suspect will be able to bring that person over to where the crime occurred or where the victim lived in order to bring the person to justice under that particular legal system. And as you'll see under the current proposals, we are contemplating extradition rules which would allow people from different countries to be extradited to other countries, not only for crimes I think we would all consider to be, for all kinds of hacking crimes, for child pornography, but also for copyright violation and those sorts of things, which, as you'll see as we go on, I'm a little soft on copyright violation. So right now, what do we do in order to deal with these kinds of procedural problems that are brought up by the international nature of computer crime? There are mutual legal assistance treaties, which are bilateral treaties between two countries, and those treaties spell out the agreements between those two countries. They generally read something like, if it's a crime in both countries, and if it's mentioned in the treaty, then we have, under these circumstances, you can have, the other country will have jurisdiction, or the other country will be able to extradite. It requires usually that the crime is a crime in both of the countries, that the offense reaches a certain level of seriousness. For searches, it requires that the offense is one for which a search could occur under the law of either of the two parties to the treaty, and often it also must be something under the treaties or under this treaty or under other treaties for which the person would normally be extraditable. There's also a more complicated procedure called letters rogatory, which is where you request that the other court issue an order as sort of a favor to you that allows a search or a seizure of some data. But these are somewhat clumsy, and the future is going to be multilateral agreements and multilateral compacts between many nations. There's substantive issues in terms of the international investigation of computer crimes, and as I said earlier, one of the things or prerequisites that we have for these treaties, for extradition, and for these jurisdictional agreements is that the countries have to agree on what's a cybercrime. It has to be a crime in each of the parties, under each of the parties' laws, in order for them to get control of the suspect. So I've listed here a bunch of different things that are possible cybercrimes that we may or may not have agreement on. So we have simple access, just simple trespass. It's a violation of the United States law, but it may not be a violation of other laws. Usually people think of this, rather law enforcement thinks of access without doing any damage as kind of a gateway crime, sort of the first step to the rest of the terror that the suspect is going to perpetrate. One question about access is, even when people agree that simple access is something that should be a crime, is there anything else that goes into that calculation? For example, it's my understanding that some countries have a requirement that the victim have taken certain basic steps in order to secure their computer, and that if the victim doesn't take those basic steps and leaves their computer wide open and the suspect gets into their system, as long as they don't do any kind of damage, that is not a crime. That's rather the victim's problem for not taking the necessary steps. That's not true in United States law. Our criminal law doesn't impose any kind of requirement or have any kind of incentive for the victim to try to make their system safe. Actually, in the United States, our law is unauthorized access. You're not allowed to have unauthorized access. And usually the way they prove that access was unauthorized is they get the system administrator up there on the stand and he says something like, "I didn't mean to let him do that. And so he didn't have my authorization." And boom, there's your one element of the crime already proved. Tampering with data, sabotage, those are things that I think there's more generally an agreement on. the use of services, theft of services, or if I clone a cell phone or something like that, to what extent is that something that's criminalized? Fraud, espionage, those are normally things that countries tend to agree are criminalized. Privacy violations, some countries take those a lot more seriously than other countries. I personally would like to see a little bit more enforcement of pro-privacy laws in the United States, but this is something that countries can agree on, although obviously everybody has a different understanding of what privacy is, and different cultures have different feelings about what ought to be kept private and what is something that the government has the right to know about. Damage and theft, intellectual property violations, which is certainly something that in earlier iterations of the law, the intellectual property violations require that you made some kind of commercial benefit from your copyright infringement. So the earlier statutes in the United States required you to be making money off of it. So you're not just copying Microsoft Word or PowerPoint because you need it for personal use. You're copying it and selling it to other people, and you're making money off of it. And it's a scam on your part. You're depriving the company from money, and that's what was enough for you to go to jail. That's not true anymore in the United States. Now, if you make copies and the total aggregate worth of the copies that you made is over jurisdictional floor, which is $1,000, then you can be criminally prosecuted for that. So what we've seen in the United States is a shift from intellectual property violations being a civil matter or a dispute between two parties over money, because presumably the basis of intellectual property to a large extent is that the owner of the property is being deprived of the value of his opportunity to sell it when somebody's pirating that property. Now it's become a criminal violation. And it's something that, criminal violation by its nature is usually something that's an offense against society. So it's definitely a shift in the way that we look at and we treat intellectual property violations, and that has been institutionalized to some extent in the international law with the WIPO Treaty, and also, as we'll see, with the Cybercrime Convention. And finally, child pornography. Now, I just want to say a little word about child pornography. It's something that there's almost universal agreement among people that it should be illegal and that it should be prosecuted. But it is not always, when you say child pornography, it covers a lot of things. And one of the issues that's been raised in child pornography law in the United States is our new laws against virtual child pornography, which is a depiction of minors engaged in some kind of sexual activity, even when there's no actual minor involved. Our statute reads so broadly that it's capable of being applied to drawings even, something that under no circumstance would you think is actually really a child, but is just something that looks like it or is suggestive and is sexually suggestive in that way. And these virtual child porn, usually child porn regulations come from the desire of the government and citizens to not have people put children in these sexual encounters and then take pictures of it and have a market for that, because it's pedophilia and we don't like that. But with virtual child pornography, there isn't that aspect to it, because there's no actual children that are used in the production of it. So this is a crime that is, or this is activity that is criminalized for an entirely different purpose. And it has been challenged in the United States on First Amendment grounds, and the courts are divided on that. But one thing that you'll see is we in the United States have encouraged other countries to adopt our regulations and our view of virtual child pornography in multilateral treaties and other compacts. So why do we need to have consensus on these matters? What's the benefits to us from consensus? If we have consensus, it means that no country becomes a safe haven for criminals. That was the problem we saw, as I said earlier, in the I Love You virus case, where the Philippines, now they think of it as a safe haven for virus writers because they don't have laws that criminalize that kind of activity. We don't want to have some country from which all the criminal hackers go to, and from which they can hack into our systems with impunity. So to avoid a safe haven is one of the #1 reasons that law enforcement and governments want consensus. It's also, as we've seen, the basis for cooperation to solve and prosecute crimes that affect citizens in whatever your home country is. Without basic consensus, you're not going to have things like searches, searches, or extradition, or that kind of thing. But consensus can be bad. And what are the downsides of consensus? Well, we don't know as legal people very much about what's going to further computer security. We don't know whether, for example, a law that prohibits all unauthorized access is going to make computer networks more safe than a law that requires the victim to take certain basic steps. And when we decide one way or the other, when we decide that we're going to have a law that prohibits all unauthorized access, we lose the opportunity to find out in the real world whether a different kind of law would have a better practical effect. We are not giving ourselves the opportunity to see whether different legal approaches are going to produce better practical results. If we just paint the whole of Europe, or Europe plus the United States, with this one set of laws and then say, this is how it's going to be. We're giving up on the opportunity to have any kind of empirical or practical analysis or assessment of whether there might be a better way. Another problem with consensus is that if we have substantive and procedural agreements, without having greater agreements about human rights and due process and that kind of thing, then we are going to be putting resources and energy and investigation efforts into prosecutions that may be unjust in other countries. If we don't have an agreement, for example, that you can't execute somebody for hacking, but yet we have one of these compacts, and it's actually, that happens because there were people who were sentenced to death in the People's Republic of China last year for hacking activity. But if we enter into an agreement or a compact with countries that have the death penalty, and obviously the United States is one of them, and we are going to be providing investigative resources, and we're going to be providing legal assistance to these countries, only to extradite the person to that country and have them either executed or have them have a trial that we don't think comports with due process or doesn't meet up with there aren't enough legal safeguards that we can be assured that the outcome is just or fair, then really what we're doing is we're not helping anything. We're not producing a situation where crimes are solved better and the world is more safe and all of that. We're just really contributing to a problem as opposed to something that's going to keep something that's going to enforce the law and going to keep the computer networks more secure. So in the service of these interests, there are current legal and political solutions that have been proposed, and I'm going to highlight some of those. First, there's been some concentration on trying to encourage the private sector to do something and not leaving it all up to government. Why? Because government is notoriously ineffective when it comes to dealing with something that's complicated like this. Industry is ahead of the game, usually, when it comes to investigating these things, when it comes to understanding what's going on with computers, and law enforcement's a couple of steps behind. You have investigators who are trained, in how to apprehend and notify or notice when people are doing hand-to-hand drug sales, or how to investigate a murder case or something like that. And now they've got to learn all about computers, and it's not easy for them. The private sector knows a lot more. So what can the private sector do? First, there's been suggestions, and I think this is a good idea, that there's got to be some kind of incentive to the system administrators to manage their private networks in a secure fashion. We don't see that incentive in the criminal law, and we have not yet seen that come up in the civil law. I'm not really aware of, there's one case that I know a little bit about, but I'm not really aware of any cases in which the civil system has been used to sue somebody because they kept their network insecure, and as a result you got hacked. But we are going to see those cases, and that tort system is going to be an incentive for companies to keep their networks secure and to have all the latest, most updated software and all of that so that they don't become zombies and DDoS attacks or that kind of thing. And I think we are going to see that, but we haven't seen it yet. One thing that we definitely haven't seen yet, and there's a big hue and cry for, is some incentive for the vendors to put out secure products instead of just putting out whatever they put out and then complaining later when somebody disses their product and exposes the security vulnerability that it contains. There should be some incentive for the vendors to start paying more attention to security. And finally, there's a proposal, one of the questions is, what can the private sector do to promote cyber ethics? Because I do think that there is a disconnect between law enforcement, courts, the general populace, and people who are in the computer security industry over what is right and what is wrong. Many of these regulations and laws are technical, they're regulatory, and I have seen many a time where somebody is doing something or wants to do something that they think is ethical or right, or in the course of them trying to find out what's going on in their system or to solve some particular problem, they do something. And while it may make sense to them as a computer security professional, the law may turn a more negative eye towards it. And many times people come up to me and say, can I do this, can I do that, what if I have this tool, what if I'm working on the project in this way? And unfortunately, because these laws are not made by computer security professionals, and because the people who make the laws are not listening to people in the computer security field, those questions, what you might think just naturally seems right or wrong or ethical, is not necessarily what the law is going to tell you is right or wrong. So how can we have some sort of consensus or meeting of the minds on what is ethical in the internet world, and then promote or educate everybody else about that? And finally, we have the multilateral agreements. And I've mentioned two groups here, which are two of the major ones. There's the Group of 8, which meets relatively regularly and discusses computer security issues, and then also the Council of Europe, which is the main thing I'm going to be talking about for the rest of my presentation, because they've recently come out with their Cybercrime Convention, and I have the URL up here where you can go to check it out for yourself. I think that Mr. Hyde has it appended to his speech in your booklet. So if you want to look at that when I'm talking about it, and so you can see the actual text, go right ahead. The only thing I would say about that is I believe, April's version, and they just came out with a new version in October. So if you want the latest and most updated, which I'm sure most people in the technology field want, and which is also important in the law, you should check it out at this URL. Okay, so the draft Cybercrime Treaty is a proposal for the European Union countries and then some others. The United States has been involved in the drafting of it, and it's also proposed for signature with everybody else. So we're not just really talking about Western Europe, we're talking about everybody. When we're talking about what's the target audience or the target signatories for this convention. The treaty addresses the problems that I've addressed earlier, what the definition of offenses should be, who has jurisdiction, how to effect international cooperation, and when and how to do search and seizures in other countries. It encourages the signatories, or mandates that the signatories of the convention pass domestic laws that are in accordance with the provisions of the treaty. And it coordinates or unifies the criminalization of both hacking, and by that I mean unauthorized access, and hacking tools, child pornography, and copyright infringing materials, as well as many other things. It provides for local authorities to pass laws that will allow them to do search and seizure at the behest of law enforcement in a foreign country. It requires, mandates that system administrators do certain preservation and production of digital evidence for law enforcement investigation. It allows for the interception in the foreign country, or rather the country where the crime occurred, of data and of real-time voice communications. and it requires the assistance and cooperation of system administrators and ISPs in other kinds of both data collection and data analysis, in data collection and data analysis. It provides for international assistance for preserving evidence, for locating the suspects, for executing trans-border searches, and also further assistance for the traditional MLAT treaties and extradition treaties that are already in effect. It also endorses the G8's major proposal, which is their 24/7 proposal, and that is a tool to help law enforcement where each country appoints like a contact person, and they have this 24-hour-a-day, 7-day-a-week network or contact list of people where no matter what time it is, you know who to call, so that you don't have to, if you're in another country, you don't have to wonder, can you get me the Manchester Police Department and work your way through there. So it provides for international assistance for the G8's proposal in that regard. And I want to talk some about the controversial provisions of the Cybercrime Convention. And as I said, if you want to follow along and look at the actual wording of these provisions, you can, because I believe Mr. Hyde has it after his presentation. Article 6 is one of the most controversial of the provisions. It is entitled Illegal Devices, and basically what it does is it makes it illegal to create, download, or post any computer program that is designed or adapted primarily to gain access to a computer system without permission or to delete or alter data.
Yeah. Excuse me, I have a question concerning this. Isn't it illegal to possess lockpicks, like sophisticated lockpicks as well?
The question is, isn't it this just like the burglary tool law, which makes it illegal to possess lockpicks and that sort of thing? And I think that that's what they would say, is that this is like that. There are some tools, but the difference is this. There are some tools which are designed only for a specific purpose, and they would argue that a lockpick, for example, is one of them. It only is capable of one use, which is picking locks. And unless you can show that you have a legitimate use for it, there's no reason for you to have it, and it makes possession of that tool illegal. But there are, in the computer security field, many tools or devices which are susceptible to two uses. And it is those tools which many people are concerned that this article would make illegal. And by that I mean a program like Crack, or a program like DCSS or something like that. One could argue that under Article 6 it might provide some protection for system administrators who could say that they have a legitimate reason for possessing this particular tool. But it's certainly not going to provide any protection whatsoever for the people who create or write these tools.
Where's the burden of proof line proving that?
The question was about burden of proof. The Cybercrime Convention does not establish burden of proof in. I imagine that that's something that's left to the law, the local law in whatever the home country is. And that is one of the problems, as I said earlier, with having consensus on some things without having due process assurances all the way across the board. And as you may know, in the United States, our due process law requires that you prove the crime, the prosecution has to prove the crime beyond a reasonable doubt. What this sounds like with Article 6 is it sounds like it's shifting the burden of proof from the prosecution, where the prosecution would have to prove that you have an illegal reason for possessing this tool, and putting that burden on the suspect, on the defendant, to say, well, I do have the tool, but I'm a system administrator, so I have a good reason for it, and to always come up with an excuse or an affirmative defense. But other countries have different standards of proof and different ways in which they enforce that. So we really don't have the burden of proof safeguard enshrined in either this convention or necessarily in the laws of the local countries. Can you stand up, please, because I can't hear you?
It states to gain access to the computer system without permission. Whose permission? The system owner or the software writer?
The question was, it says that you can't have it to gain access without permission. And the question is, whose permission? And that's a great question. As I mentioned earlier, in the cases that I've seen, the way that they prove that the access was without authorization is they get the system administrator up there to say, yeah, I never meant for him to do that. I would like to see the law have something more to do with your more formal sense of authorization. If I can get in and do it without offering a password, then it seems like it's something that's authorized. But, you know, if that's not what the law has been in the United States, and there's no real definition of that. Once again, it's something where the criminal law is not encouraging system administrators or the potential victims to take even basic precautions in order to keep people from doing things that they might not want done on the system. And that puts the burden on the snooper, on the potential suspect, to know what it is that the system administrator wants him to see or doesn't want him to see. And the suspect then has to guess. And without a lot of consensus or agreement on cyber ethics as to what's right and what's wrong once you're in a system, that really is just a matter of personal opinion. I have had cases many times where the victim took offense at what happened to them, but you ask other people and they'll say, well, it's really no big deal. I can't believe that your victim's getting so upset about something like that. So I don't think our criminal law should be so subjective, but unfortunately that's what this is. It's subjective.
So, question. So based on the way you're saying that the burden of proof is shifting across to say to prove that you're not going to use it in an illegal manner, it sounds like there's a great lot of potential for the law to be applied and prosecuted in a very arbitrary manner. Is there any way to protect against that?
The question is, with the shifting burden of proof, doesn't it seem like the law could be imposed in an arbitrary manner, and what can we do in order to guard against that? One of the main safeguards against arbitrariness is specificity. If we have a law that's very broad, then prosecutors can pick and choose within the universe of people who may have violated that law and target people for whatever reason they really want for prosecution. If the law is specific and specifically describes exactly what is and is not illegal, that first of all targets or narrows prosecutorial discretion, which I think is something that we want. But even more importantly, it gives notice to the suspect or to the computer security professional or to the average citizen of exactly what it is they're not allowed to do. And when you have notice and you can tell what's illegal and what's not illegal, then you can make a choice as to whether to adhere your conduct towards the legal side or whether to cross that line and take your chances. But when it's something that's vague and we don't know, it's both arbitrary and also vague and unfair. Article 9, I mentioned earlier about child pornography, internationalizes the United States law that would make it a crime to possess digital images that appear to be child pornography, even if there's no actual child involved with that in the production of that picture. Article 16 about the preservation of traffic data requires the system administrators to preserve logs and data and that type of material for review by law enforcement later. And this is extremely critical for the reason that Mr. Hyde stated earlier. You may remember earlier he said that you don't have to worry much about RIPA or anything like that because doing data interception is so expensive that it's just not something they're going to do for the casual offhand crime. It's only something that they're going to do for the real serious crimes. It's just too expensive. What this provision does is it shifts one of the expenses, the expense of preserving and maintaining traffic data, to the ISP. Now the government doesn't have to do it. The ISP is going to do it for them. So there goes one of their motivations not to do intercepts on a much broader basis. This is also the problem with the carnivore device in the United States, which some of you may have read about. Are people familiar with carnivore? Okay. The problem with carnivore is this. Under the United States law, to get a wiretap, not only does it have to be for a certain crime, and you have to have probable cause, but also you have to show and you have to show that there was no other better way to get the information that you're looking for other than the intercept. But most finally, you have to have minimization. And what minimization means is that you can't listen to everything, you can only listen to the important stuff. So if I'm doing a phone tap, what it requires, I'm the FBI agent, and I'm listening on the wire, and the suspect's grandmother calls and they're talking about some cookie recipe, I have to hang up. And then 2 minutes later, I can get back on to see if they're still talking about that. I have to hang up. If the lawyer calls, I have to hang up. But if his co-conspirator calls and they're talking about football, then I have to hang up. I can't listen to that. And 2 minutes later, I come back on, and now they're talking about the drug deal, and now I can listen. Okay, that's what minimization requires. It's a very expensive proposition because you have to have somebody sitting there on the phone, listening all the time, hanging up and checking back in and that sort of thing. But what devices like Carnivore do is it makes the data collection so easy and so fast and so quick to sift through later on that disincentive to broad, wide-scale interception disappears. And now you have no financial disincentive whatsoever. The only disincentive you have is legal disincentive. And as everybody knows, both for cops and for criminals, sometimes the law is not enough to make people behave a certain way. Sometimes economics has a much more powerful effect. And the preservation of traffic data provisions were particularly targeted by the International Working Group on Data Protection and Telecommunications, which criticized the provisions that require preservation of the traffic data. Article 14 is also controversial, which deals with search and seizure, and Article 15, which deals with producing the evidence for law enforcement review. These articles require the subject to process data under his or her control and then yield the necessary information to authorities. Let's just take a moment to think about this. They're going to come to me, the suspect, and they're going to tell me, you go through everything that you have on your computer, and then you turn over to us everything that's incriminating that we want.
That'll work.
Yeah, that'll work. First of all, it doesn't seem like a good idea from their point of view, because they're really putting it kind of in my hands to do it, also in the ISP's hands, or possibly in the system administrator's hands, but in the suspect's hands, which sort of seems counterintuitive. It also runs into legal problems in terms of self-incrimination, because they can't require me to participate in producing my own conviction. If they want to convict me, they're going to have to do it without my help. That's what the Fifth Amendment means in the United States. So it runs into serious problems there. But if the United States becomes a signatory to this convention, then what does it mean for the Fifth Amendment? That I don't know. It requires the person with knowledge to seize and secure data for investigators. Again, this could be the system administrator, but it could be the suspect themselves. And what does that mean? What is the, if they say it in a sentence or two in the convention, but what does it mean, for example, for the production of encryption or encryption keys? Can they require me, because I have knowledge, to give encryption keys over or to give my passphrase over? And as I said, what does it mean for the United States Constitution and for the principles against self-incrimination? And finally, Article 21, which deals with extradition. It provides for extradition for all of these offenses, not only for the offenses that I think we would all agree are serious offenses like child pornography or theft or damage, but also for things like these kinds of low-level copyright violations. The Group of Eight, as I said, is another international organization that has been working on these issues lately with far less consensus and a lot more squabbling, actually, than the Council of Europe, and perhaps for that we should be grateful. Their main accomplishment is the 24/7 network, which I described earlier, a sort of resource for law enforcement. The primary dispute that they have is whether there should be an international law enforcement organization for cybercrime. And my understanding is that the United States has been supporting the creation of such an organization, while France doesn't really like that idea very much. So, go France. And what are the principles, basically, that the Group of Eight has agreed on? And I think these are principles that we can all sort of get behind. they've agreed that any kind of international agreements or laws about dealing with internet or computer crime should ensure the protection of individuals' freedoms and private life, preserve the government's ability to fight high-tech crime. Those are two things that are often in direct contravention of each other. Facilitate training, and all these principles that I've listed up here. Did you have a question there?
Yeah. Assuming that this draft treaty gets signed by any number of signatories, they're going to be in the creation of some sort of international agency. Where are these cases, number one, going to be tried? Will be tried in the local jurisdiction of whether the attacker was or whether the attack took place? Number one, and number two, as with most treaties, they're only worth the paper they're written on. Are there notwithstanding clauses that will allow countries to back out of it?
So the question is, assuming that the convention gets signed by a bunch of countries, what does that mean in terms of where people are going to get tried, and are there ways that parties that sign the treaty can get out of their obligations under the treaty? And yes, the treaty does say where people are going to get tried. It has provisions that state where jurisdiction is appropriate and provides for extradition for all of these offenses. So a United States citizen who attacks a computer in France can be extradited and tried in France. That's basically what the treaty provides for. There may be other elements that go into it, but that have to do with other treaties between the two countries or something of that nature. But that's the basic provision that this treaty establishes, because as I said before, if the crime is illegal in both of the countries, if the crime is of a certain requisite level of seriousness, if it's a crime for which search and seizure could occur in either country, those sorts of things, then it's the type of crime that they're going to allow extradition and foreign jurisdiction for the prosecution thereof. In terms of how to get out of it, I'm not an expert in international law or in treaties. I understand that there are many different ways that a signatory can disobey a treaty, and there's not necessarily a lot of recourse for the other signatories to the treaty, other than sort of their disrespect for the wayward party. But the convention itself is pretty matter of fact, and you can take a look at it and see there's not a lot of, you can do this except if this is true or that kind of thing. It's pretty laid out in pretty basic language. So the convention itself doesn't allow for a lot of exceptions. For example, it doesn't say this is true except if the penalty in the other country is the death penalty, and in that case we don't have extradition. Now, I know that a lot of European countries, for example, won't extradite people to the United States unless they can get a promise from the United States that we're not going to seek the death penalty against the person. So there's other things that go into that calculus, but nothing really that's in the convention itself. So so just to wrap up, international cooperation is the trend, and that is for the reasons that I stated earlier. Consensus makes finding the suspect and prosecuting them easier. It also prevents safe havens from developing where there's an island of criminal hackers who cannot be reached by the long arm of the law. But there is a downside to international cooperation, is that we lack that laboratory opportunity that I mentioned earlier, and it's that we don't have consensus really on due process or sentencing or burden of proof or those sorts of things, and that is definitely a reason to be concerned about the rush to cooperation without other safeguards in place. And as consensus is being crafted in the Council of Europe, cautionary voices are being ignored. This convention was initially published in April, and they asked for comments, and many, many people wrote in, particularly about Article 6, the illegal devices article, which made many system administrators extremely nervous. And many people wrote in and explained exactly why Article 6 was detrimental as opposed to helpful to computer security. And as a result of all that input, the Council of Europe made almost no changes whatsoever to Article 6. All they promised is that eventually they might produce a list of authorized uses for these illegal devices, so exceptions under which if you fell, you wouldn't be prosecuted, you wouldn't be guilty of that crime. But that is a far cry from taking into account the vast and eloquent kinds of complaints that people made about that particular article and the other articles as well. The choices that we make now, both as countries that will be parties to the convention and as the people in the Council of Europe are crafting these conventions, are far-reaching. And as we all know, the law is sort of a dinosaur and can be very slow to change. The things we set down in law now, we're going to be living with for a long, long time, and we are not going to be able to overthrow those as easily as we might like. So the ramifications of the decisions we make are far-reaching, but our vision is not necessarily that far. There's a lot of things we don't know. It's a very new area of the law. There's a lot of things we don't know about what the law can do to both help and hinder computer security. And unfortunately, it doesn't sound like we have any kind of process in place through which those concerns are really being taken into account in our lawmaking work. So the benefits of consensus, which I mentioned, are only going to outweigh the detriments if we're very careful about how we craft these conventions and treaties. And that is an opportunity really for all of you to take a look at the Cybercrime Convention and to think about it and to see whether you think anything that's in there is going to have some kind of impact on the work that you do, because you guys are the ones who are the professionals who really know. The people at the Council of Europe, the people in the United States Congress, the people in Parliament may know nothing at all whatsoever about computer security, and it's an opportunity for us as citizens to try to raise some kind of hue and cry, and perhaps we'll be ignored, but at least we'll know that we gave it a good shot, and then in the end, when it's all messed up and computer security suffers and there's no incentive for victims to make their systems safe, we can say, hey, don't look at me, I wrote my letter and I gave it a shot. But I do think that this is a concern, and that as decision makers and as people with as the people with knowledge that the convention refers to, we have to be careful about rushing to consensus without taking all these other things into account. Thank you. Okay, I have lots of time for questions, so let's have some questions. No questions? My position on copyright? I believe that generally copyright is something that should be a civil matter. It's an economic dispute between two parties, and that we've over-criminalized copyright. We've criminalized it down to a very low level, and I don't think that that's helpful. And I think as a result, we come upon situations where the copyright law is used to hinder other beneficial either legal advances, economic advances, or social advances. One example of that is how the copyright, the protections against, the legal protections against circumventing copyright protections are in opposition many times to fair use, and fair use has suffered as a result. Technology suffers as a result because we see how the Napster technology has been put at risk by over-enforcement of copyright law. And economically, I think the same thing with Napster. Record companies want to continue to be paid for distribution when really the internet does distribution far better than the record companies ever did. So we're sort of legally institutionalizing a dinosaur there, which is record companies getting paid for distribution, when really there's no economic benefit to that. So I think copyright protection is important, and I think that artists should be paid for their work, but I think that the way that we've been doing it has been, I think the way we've been doing it is over the top and is detrimental to several important things.
Using the European Union as an example, international corporations all very well, but won't it be the fact that either everything gets watered down to make more people sign up, or you'll end up with less signatures?
And so the question is, doesn't just the fact of needing a lot of people to sign these multilateral treaties mean that everything gets watered down sort of to the lowest common denominator? And I think that that's definitely the case. I mean, this is a pretty, if you look at the Cybercrime Convention itself, it's a pretty broad document. It doesn't have a lot of specifics or that kind of thing to it. It just has some very broad principles or general agreements. And as I said, I think that leads to confusion for the people who are trying to follow the law, and confusion for law enforcement and prosecutors, and that there's a downside to that confusion. First, that people can't conform to the law, and second, that prosecutors then have an immense amount of discretion, and that's unstructured by the law.
You mentioned viruses in the Philippines missing some laws. Are there now any laws in the US against creating of computer viruses or more general untargeted attacks?
So the question is, does the United States have any laws against creating computer viruses? And the answer is no. Writing a computer virus is fine. Putting it out there is a different story.
Are there any international organizations that carefully watch this trends that you showed us and raise their voice to really make people aware that this might easily end up in the witch chasing of our century just because people don't understand and fear a technology they don't understand?
The question was, what kind of international organizations, if any, are out there to raise questions about these types of treaties and the potential problems that they can have that I've raised. And I mentioned one, the International Working Group, which is a group of European Union privacy commissioners. There are some civil rights groups that are based in the United States, like EPIC and EFF, that work on those issues. Apparently we need more and more strong voices about it, because the concerns that are being raised aren't being listened to. There's also been some sort of ad hoc groupings of people where a bunch of professionals in the field have gotten together to sign letters to the Council of Europe, to raise these issues and stuff. But I don't know of many. There's not like one international group that I would say, yeah, they're the people who deal with this. And there's Privacy International, which is based in London, and groups like that you can contact, and they're colleagues with other groups, but there's no one overarching sort of international umbrella group that I would say, oh, those are definitely the people to talk to. Did you want to follow up?
And how much is this political trend backed by the industry, and how much is the industry standing away from that?
So the question is, are the industry's hands dirty in this? And I think that the answer to that is yes. Industry, when we talk about shifting costs, because economics has a lot to do with this, industry wants to shift the costs of protecting themselves away from themselves and having to bring a civil suit and over to government, because then the taxpayer foots the bill, and the taxpayer is the one who figures out, who hacked the victim and how much restitution should be paid and all of that. So I think that it's in industry's interest really to push the problem away from their responsibility, both to maintain secure networks, to put out secure products, to prosecute their own interests when they're economically harmed, and to push that onto burden on the citizen or the potential suspect to obey these rules, and then onto law enforcement or the government to punish and to seek redress for them when those rules are violated. So yes, that is one of the reasons why we have chosen to deal with computer security in the criminal field. And that in itself is a value choice that I'm not so sure is going to produce the result we really want. And we all agree that the result we want is better computer security. But is the criminal law really the best way to go about that? And that's a whole nother speech that I'm not going to give you right now, but I think that's a serious question. And there are other ways which we're neglecting, and other areas of the law that we should be developing better. For example, setting some kind of basic standards for system administrators to adhere to, so that we know whether they've done due diligence in keeping their system secure. Something like that we could work on. So, seems a lot easier to me than trying to, search and seize and get the suspect to process the evidence for you and all of that. But that's just me. Other questions? In the back?
Currently, as I understand in the U.S. law, and I believe that it's coming over in Europe, I haven't checked it, there's actually legislation which is going to allow, or proposed legislation, which will allow software vendors to remotely access and enforce software licenses. How is that going to actually work in what's being proposed by the Council of Europe.
Okay. The question was, isn't it true that United States law allows software vendors to remotely access machines to assure that their copyrights are being respected? And how does that have anything, does that affect or have anything to do with this particular convention? And unfortunately, I don't think the convention criminalizes or prohibits something like that. In fact, United States law will prohibit users from disabling a function like that that would remotely scan your computer to determine whether you've violated copyright, because the anti-circumvention provisions of the new Digital Millennium Copyright Act prevent you from trying to get around something like that. It seems to me that one of the main things that has there's two main things that have prevented that kind of practice from being really widespread in the United States, and neither of them is really the law, or rather statutory law. One is a potential fear of liability on the part of the software vendor, and the other is public outcry when that kind of software is out there. But you don't always get to know what is happening to your computer when you visit a certain website or run a certain program or something like that. So yes, that's very scary.
But isn't that seen as unauthorized access?
The question is it unauthorized access? And I think the answer to that is, I'm going to argue as the software vendor that when you run my program, if you read my fine print, you would see that you authorized it. It's part of the shrink wrap license that you authorized it when you're running my program. Or as if you have some of my products, if I have some Microsoft products, Microsoft shrink wrap license may say, I authorize Microsoft to, when I install this product, to check and see whether I have any unauthorized copies of Microsoft stuff on my computer and email back and let them know. I don't read all that. I mean, I'm a lawyer and I don't read all that stuff when I buy software. Install, I click accept, and I install it, and I think that most people probably do the same thing. But that's how they'll get authorization, through your somewhat unwitting consent. And of course, your argument then is, I never would have consented to that if I had known, and it's an adhesion contract, and the principles of contract law apply to interpret that, and you can battle it out in court and everything. But that's going to be how they'll safeguard, how they'll try to safeguard themselves. I think there have been fears of that kind of liability, as well as the possibility that the system will, they'll do something to the system, or they'll find out information beyond that which, any court would allow them to find out by accident, and then, there's going to be some liability or lawsuits associated with that. But it's not enough of a deterrent to companies to not do that kind of proactive scanning for infringing materials.
I suppose you could always say, fine, you can access the box, but if you breach my network and stuff, you can go to the box if you want, but if it comes from a firewall, then you're I don't want you in the firewall.
Well, you can, when you buy that copy of Microsoft Word, you can call up Microsoft perhaps. The question is, when I can give authorization just so far and not further. And you can call them up maybe and negotiate that, but that's not going to work. You're right that authorization to do something doesn't mean you have authorization for everything. I always like to say that police officers are a little bit like vampires. You don't let them in your house, they can't come in your house. But once you let them in, they have free reign. Well, authorization's not the same way. You can say, I authorize you to look at these files only, but not this other thing. And as you haven't consented to allow a search beyond that, and that may be some sort of safeguard. But that's going to be, as I said, something that's all dictated by contract law and the provisions of contract law. Somebody in the back, yes? Have the shrink wrap licenses been challenged? And my answer to that is no, not yet. That is something that I would like to see in the future, and hopefully I'll personally have some hand in. If anybody has a good shrink wrap license challenge case that involves some kind of privacy or free speech issue, I encourage you to bring it to me. I'm going to be leaving my current job as criminal defense attorney and going to Stanford Law School, and while I'm there, we're going to be working on cases in technology that raise public interest issues, and shrink wrap licenses is definitely one of the ones on our list of things to target. So if you've got a good case that raises those issues, please do let me know. And there's my email address, so feel free to write to me and tell me about it, because I'd love something like that. The shrink wrap licenses can be very oppressive. Yes?
A question a bit outside of your speech. It said here in the information about you that you have spoken to the NSA. What did they ask you?
That was really something. When I went to the NSA, I gave them my speech on whether criminal law was the way to deal with computer security. And I argued no, that there were risks associated with the over-criminalization of hacking. And that as a result of this over-criminalization, we actually were having less secure networks, and we really weren't benefiting at all. And of course, as a side, since the NSA kind of doesn't care, it was a violation of people's civil liberties as well. And there were several people who got very mad and yelled at me and said, if it was you, sort of asked me the Michael Dukakis question, if it was your network that got hacked and your private information that was stolen by a hacker, you would be upset and you would want that person to go to prison, wouldn't you? Questions like that. So they got really mad. But a lot of people there, I think, I wasn't just inflammatory. I think that the point is a good one, which is that we have a common interest, which is promoting the health of the network, and the question is really how to do that. And the criminal law is kind of a blunt instrument, and there's other better ways. I think the criminal law can help, but if we're really expecting it to carry far more than its burden. And I think a lot of the people there at the NSA were actually receptive to that. And they thanked me, and my speech was one of the more popular of the 120 presentations that they had. Mine was like number 4 in terms of popularity. I was beat out by Kevin Polson. His was far more popular than mine, but that's okay. I'm happy to play second fiddle to him. So, yes?
Is Article 6 against the freedom of speech?
You're asking me about Article 6 and the freedom of speech?
Yes.
I think that its freedom of speech issues are primarily associated with creating devices that permit fair use, like DCSS or something of that nature. The main objections to it haven't been primarily on free speech grounds. The main objections have been, without these tools, we can't do any kind of network analysis or keep our networks secure or anything like that. We use tools. These tools are susceptible to 2 uses, an evil use, if you will, and a positive use, and without them, we can't be good system administrators, and this regulation perhaps might protect us as system administrators because we can come up with like a good reason, a legitimate reason why we possess the tools, but it's certainly not going to help the people who we rely upon to write these tools. But the free speech part is raised when the tools are something, like I said, like DCSS, that allows for fair use even when otherwise there might not be fair use permitted.
But what will happen? What will happen if I post to a mailing list saying I have something new? It's a problem with that and that. You don't say what is the problem, or I will outline the problem. Then I could be prosecuted as well. I didn't create a tool, but I set the road for others to create a tool.
Okay, so the question is, what happens if I then post to a mailing list something to assist other people to create this tool? And the Cybercrime Convention does have rules about aiding and abetting and conspiracy. And aiding and abetting or conspiracy to do any of these crimes is also a violation of law under this Cybercrime Convention. So that is still a concern. I think that's exactly part of the problem. And I want to make clear that this isn't law yet. I mean, it's not too late. The horse is still in the barn. It's not too late. Possession of these tools is not illegal under United States law at this point. It's basically you have to, in order to. You can, I think it's not legal under federal law, but there have been cases where certain security tools have been charged, people have been charged with possessing them as using them for burglary tools, but in the situations where that happens, they almost always were actually used in burglaries. This is going to outlaw the possession of the devices generally, so it's a little bit different. But yeah, I think that kind of thing is one of the main concerns. And I guess what you're saying there is like, that's a free speech issue, because why can't I talk about what kinds of things are needed? Now I'm going to be liable as an aider or abetter. Was that your point?
It's just in contrast with full disclosure, because full disclosure speaks about, okay, I will give the companies a bit of time to respond to what I found, and if they will not respond in time, I will post the problem. Then it will say, hey, you cannot post the problem because you outlined the way for others, or they can use your links in order to do the stuff you say. So,
Right, so what he's
full
saying is that
disclosure.
what he's saying is that Article 6 is in contravention really to full disclosure because it can be interpreted to prevent you from publishing information about a security vulnerability that you found in some vendor's software, even if you gave them ample time to fix it and repair it and they didn't fix it. And that's not only a free speech problem, but that's a problem in terms of whether you think about this law making the networks more safe or less safe, and that's definitely an issue. Now, I know people feel very differently, and there may be some disagreements in the security community about full disclosure, but I would like to see those disagreements settled and come to some sort of idea or consensus about what's going to promote network security before the legislators come in and say, we don't care what promotes it or doesn't promote it, Article 6 is the law, and you're just going to live with it.
That also goes against the part of the ruling articles where they say countries should produce secure systems and software. When we find out how the holes in these systems is why people like us in the community going out there, looking at these systems and finding these vulnerabilities and then making them known. So no one's going to know, so the company's going to get away with not producing anything secure.
So the comment was it also goes against encouraging the companies to make secure software because if people like yourselves can't go out and find these vulnerabilities and publish them, then what's going to be the incentive for them to make secure software? I just want to make clear that that thing that I had put up about what private industry can do in order to help prevent computer crime was things that people are talking about but are not part of the convention itself. I just want to make that clear. So there are things in the convention that I think do directly contradict other values that we might have and other proposals that we have for how to make the network more safe. There was a question, but yes.
I'd like to start my question with a comparison between the paragraph Article 6 and arms control, because arms control can help to decrease vulnerabilities in the public, and if arms control can do that, Article 6 can maybe do it also, because if you compare an exploit to a fully loaded weapon, and you permit people to not carry, do not permit people to carry a loaded weapon, yeah, you can decrease act boxes.
Right. He's saying an argument, a countervailing argument to what I've been saying about Article 6 is just like arms control produces a safer world because not everybody has weapons, so Article 6 can produce a safer network because not everybody's going to have the tools to break into each other's systems. And I think in some ways that's
bad guys.
Yeah, it's going to send it underground with
Yeah.
my arms.
It's a little bit tricky to download a gun.
You could also say, you know what they say in Texas, an armed society is a polite society. So I think in some ways it does depend a little bit on your point of view. But I think that in some ways the key is that the key is that there are things that we get out of these illegal devices that Article 6 prohibits that we don't get out of, we don't necessarily get out of ICBMs or something of that nature. But I think your point's a good one, and I don't mean to argue against you. I think your point stands on its own. Go ahead.
I think the problem with the whole thing is that we really draw the line. By talking about vulnerabilities is, I think, definitely First Amendment, but writing the software that is able to exploit it is not First Amendment anymore. It's no weapon. So, and having a scanner is not a fully loaded weapon, it's just a scanner that looks for weapons. So, I think the problem is, yeah, where the line is drawn by legislation and the judges who sit on the cases.
So the question is, it's a question of where you draw the line, talking about the vulnerability, maybe free speech, but writing script or executing it is loading and firing the weapon. And I could really disagree with that, I think, in a lot of ways, but and we could debate it, and perhaps we will later on this evening. But I think your point's a good one, and I think it stands alone. It is something about which I do think that reasonable people could differ, but there is no consensus. We haven't talked about it, and the laws come down on one side or another.
The question's on statute of limitations on digital evidence. I mean, normally statute of limitations are based on people moving or forgetting or dying or something. But with digital evidence, it can be kept forever. Is there anything to prohibit somebody from, say, like your employer getting the goods on you because you did something illegal at work, and then coming after you 40 years later because the evidence is still preserved?
Right. So the question is, what's the deal with statute of limitations? I mean, normally evidence degrades over time, and it becomes hard to bring a case later on. Each of these offenses has a corresponding statute of limitations. And I don't think that this is going to change those statute of limitations, because in addition to, one of the reasons for statute of limitations is certainly that we want people's memories to be fresh and the witnesses to be fresh and that sort of thing, so that we have more reliable prosecutions. But there's other reasons for statute of limitations too, and it's to sort of settle matters and kind of get business finished with. And I don't think that we're going to see, there hasn't been a big push to make the statute of limitations in these offenses much longer than they currently are, and I don't really think we're going to see that kind of thing, because I think the statute of limitations in the United States for these is something like 5 years or something, and that's ample time for them to do these kinds of investigations. And exactly the kind of thing that Jeff's talking about. You don't want your boss to be able to, while you're working there, he's got the goods on you, but 20 years from now when you leave and you go to a competitor and he's mad, he's suddenly going to bring up this digital evidence that he's preserved forever. So I don't think we're going to see, I don't think there's a big push, and I don't think we're going to see a lot of changes in applicable statutes of limitation.
At the end of the day, if you have committed a crime, even though 40 years later, if you can prove that you've committed a crime, then surely that is the right thing to do.
So the question is, if you've committed a crime, even if the statute of limitations has passed, can't they pursue you anyway? And
but not necessarily that. But if you can prove that you have committed a crime, such as in England, there was a recent somebody was done for murder because of the DNA sequencing got a lot better since they committed the crime. They were brought to justice 20 years later. And I'm just saying that a similar sort of thing could affect computer crime. Where it's probably different from something like blackmail is what we'll be on about, isn't it?
well, I think what you're saying is there's been cases where old murders have been solved because of advances in DNA testing technology, and those people then get tried even 20, 30, 40 years later, and that's true. The primary reason for that is that there is no statute of limitations on murder. You can bring a murder case however long after the fact that you want. And then the statute of limitations decreases kind of depending upon how serious the crime is. So for relatively unserious crimes like misdemeanors, you usually have a statute of limitations about a year. For more serious crimes, felonies, the statute of limitations would be 2, 3, 5 years or something like that. And it's really to promote finishing business. It's just to keep everything kind of clean. It's sort of an administrative thing in a way more than anything else. And I think that if there was some kind of really tragic, horrible thing that happened, that involved computer crime, they'd find some way to bring it after what you might think the applicable statute of limitations is, but generally, no. Yes?
Yeah, I have a question back to the possession of tool. When do I possess the tool?
When do you possess it? Possession is not just your physical having it, but also includes constructive possession. And constructive possession is like one of those legal concepts that you really need a lawyer to define for you. We do that on purpose so that we always have jobs. We like to make it as complicated as possible. And it involves, constructive possession involves the right to control, the right of control or dominion. So I can be convicted of possessing something, even if it's not on my system or not on my workstation or anything. If it's on my, let's say, my minion or lackey's workstation, that I have the right to order them to do things, and I kind of have control over what's on their workstation, even though I've never actually touched it or
So like
whatever.
the tools on my laptop,
So these are like, well, I don't know what they are. Knowledge is
Oh.
definitely one of the elements of it. Possession usually almost always requires knowledge. I can't just have it near me, or it can't just be, you know, you put it in my hand and I don't know what it is, that I'm not possessing it. I actually had a case like this that I won really recently where my client was standing on a sort of crime-infested street corner in San Francisco, and some guy walked up to him and put something in his hand. And this was in the police report, I didn't even make this up. Put something in his hand, and my client looked at it, and the police are over there. My client doesn't see that the police are there. He looks at it, and he says, it's a rock of crack cocaine. My client says, I don't want a rock. Then he looks up, and he sees the police, and then he drops it on the ground. And they charge him with possession because it was in his hand. But he didn't know what it was, and since he just spontaneously declared, I don't want this rock, then I managed to win. So yes, it's not just touching helps. Thank you. Touching it helps for possession, but touching is not enough. And touching is the only thing. I can never touch it and still possess it. It's a question of dominion and control. Yes?
What about tools that are, say, posted to a public mailing list? There might be hundreds of thousands of people who know where to get the tool. Do you have to say something?
No, because they don't have control over it. I think they'd have to take that extra step of going there and getting the tool before they would have the dominion or control over it, the ability to use it. And I think that that's what they're talking about. When you're talking about possession, you're talking about, do they have the ability to use it, or is there another step that needs to be taken before that can happen?
Even if it's in their own mailbox?
Well, like if it's a link or the program was actually sent to me.
As an attachment.
Like if they say somebody sends me the program as an attachment or something like that, and then I just left it on my hard drive. You know, this comes up a lot in the child pornography situations where possession of child pornography is illegal, and usually what it requires is just that I know the nature of the thing that is on my drive or on my network. So if I know the nature of this program and it's on my computer, even though I just sort of left it, you know, as a link to something that's in my inbox, I think that arguably I'm still in possession of it. Like I said, this is one of those things that we lawyers like to fight about, and there's millions and millions of cases on it, and there's no clear answer, because if there were, you know, that'd be too easy and people wouldn't even need us anymore. But that's what I think that the answer would be. If it's in my inbox and I kind of know what, and I know what it is, then I'm in possession of it, regardless of whether I took any steps to bring it there. My responsibility then is to erase it.
Suppose it's in somebody's signature. It's an online pearl.
Or like those T-shirts that have DCSS on it.
Can free access to something being in a position of also? Like if I have free access to something, can I be told to be in possession of it?
If you have access to something?
Yeah, free access to something like it, but it's not on my computer.
So for example, the tool is on some remote machine on some I can get it through some website somewhere, but I don't have it, but I know how to get there, or I have a link to it in an email, then I think that's not, I think that the courts would probably say that's not possession, because you have to take the extra step of going there to get it. That's what I think they would say.
I have a question about anonymity. If I provide a service like Mixmaster or so, which protects the traffic data, will I be punished against Article 6 as an illegal device or illegal service, and also against Article 16 because I protect the traffic data and no one can track the communication between A and B.
So can you explain to me what this service does?
Anonymous remailer.
Oh, an anonymous remailer.
Yes, maybe Mixmaster or Crows or you don't know this one.
Many people have complained that this cybercrime convention would make anonymous remailers illegal. I'm not sure that that's directly true, but I know that many people have raised that question. Both because the system administrators are required to obtain and maintain certain data, and also because
I will kill all logs because I have a German right. I don't eat the logs, and I kill it every second or every minute.
Right.
So I provide illegal service. Maybe this is low.
Right. Well, what this convention, what this agreement would do is it would enable your country, Germany, to pass laws that would require you to maintain those logs. And that's one of the that again is one of the main complaints commissioners and other people have had about the preservation of logs provisions in the convention is exactly that, and they're afraid that it puts things like anonymous remailers at risk. And once again, I should say that anonymity does have a free speech aspect to it that's very important and critical. And here we have a simple provision that says ISPs and system administrators. Just like Mr. Hyde said during his presentation, he said, we're telling system administrators it's not just our problem. We're all in this together. We're going to work together for computer security. And I kind of, I smiled when I heard him say that, because that's what it looks like. It looks like we're just, ISPs and law enforcement working together to stop these crimes. But, we're talking about preservation of traffic data. We're talking about some serious First Amendment and privacy issues, and these are other crimes, really, that are being committed in the name of preventing hacking.
One more question.
One more question. Okay, no more questions. Thank you very much.